Be seated. We'll hear argument in case number 240782, Busse against South Texas Independent School District.
May it please the court, Ms. Leon will present argument for the petitioner. Ms. Petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court. This appeal concerns the standing of individual taxpayers in the Texas Public School District to raise constitutional challenges to a tax that was never authorized by the voters. The individual taxpayers challenge South Texas ISD's school tax because the question of whether a school tax should be charged in Willacy County to support South Texas was never issued to the voters. South Texas is no longer carrying out the purpose for which the voters approved a tax back in 1974. The 1974 election order makes clear that the 5-cent property tax that was authorized was to operate a rehabilitation district for the purpose of serving disabled persons in the Rio Grande Valley. At this point in time, the rigorous academic program that South Texas ISD has, which operates almost as a magnet school for gifted and talented students, actually discriminates against disabled children. And you can see that by the fact that less than 3% of its students are actually students with disabilities, as compared to 10 to 11%.
How does that prove discrimination?
It doesn't prove discrimination, although in the record at the trial court there was testimony from parents of disabled children that they believe that the rigorous entrance application process did in fact discriminate against disabled children. That evidence is in record. And the taxpayers also object to the tax because the Willacy County taxpayers are paying a stunning $62,500 per pupil. That was back in 2022 when the case was heard. To send local students to South Texas ISD while they're only funding local students at a rate over $5,000 per pupil. And this is precisely the kind of gross disparity that this court in the past has determined to be unconstitutional in giving rise to standing of individual school districts and taxpayers and parents to challenge those unfair policies.
Do we say that school districts have standing to challenge the taxing authority of each other when there's overlapping jurisdictions, or do we say that they're standing to challenge the state's overall education funding allocations? So you're talking about contributions, but that doesn't necessarily match with the state's ultimate allocation of education funding. And the concern that I have is that there are lots of overlapping taxing jurisdictions in Texas. And if we allow suits between and among those jurisdictions about whether someone else's taxing authority is being properly used, we're going to see a lot of these kinds of cases.
Well,
which I don't think we've seen before.
I think this is a good point. I think this is a unique case because we'll talk about in a minute about why South Texas ISD is unique. And this situation is not likely to be seen elsewhere in the state. But in the school finance challenge to the CED tax, I think it's similar in that the school districts were saying the CED tax needed to be permitted to go to the voters before it could be charged because the school districts believed it was an unconstitutional tax. I think in the Morath case, this court has also said any school district in Texas has standing to challenge a violation of the Texas Constitution when it comes to school property tax.
Turning to the individual taxpayers and not the district, the briefing frames the standing question as one of taxpayer standing. And I want to get your thoughts on whether that is the right path when we're talking about a claim that challenges the collection, the authority to collect tax versus an expenditure of the tax.
Well, unlike other taxpayer cases that have been before this court in the past, in this case, South Texas ISD makes the decision each year as to whether it's going to charge a tax. So it's every year it's making a separate decision, which is a new constitutional violation when they do so. So I think it's a little bit different in that way. I do think it's proper to phrase this as a taxpayer challenge. The taxpayers here have never had the ability to vote on whether they should be taxed to operate a second public school system within their jurisdiction. And because it's on top of their existing tax, it creates an incredible burden on that.
But in terms of the precedents on taxpayer standing, some of them describe taxpayer standing as an exception to the general, constitutional standing test. And I wonder, is that triggered do we go to that exception, if you want to think about it that way, when what's being challenged is the collection of a tax?
We're objecting to the assessment.
Right.
And we're asking the court to enjoin the collection for the 2025 tax year. So we are challenging, the petitioners are challenging the assessment.
And I think the question is that because what you're challenging is essentially the tax bill, each taxpayer is, in theory, owes the money and is challenging the money that they owe individually. You may not need this notion of taxpayer standing, which serves the purpose of getting around the particularized injury requirement of standing sometimes, because we're not talking about a situation where everybody is sort of diffusely impacted by the actions of the government. We're talking about my tax bill that I feel like I shouldn't have to pay because it's illegal, and that's just a direct injury in the classic sense, and so we don't need to talk about taxpayer standing.
It is a direct injury in the classic sense, but I think the problem with approaching it in that way is showing a particularized injury because all of the Willacy County taxpayers are treated in the same fashion.
But we said in the Data Foundry case that was not a problem, where there was an assessment that was being paid to the electric company, and just because everybody had to pay it didn't mean that the injury was not particularized, because you were still taking money out of your own pocket, and so therefore they were standing.
If the court determines under either theory that the taxpayers have standing, we'll be satisfied with that outcome. I was really looking at like Crowd versus Celeste and the Houston versus Gonzalez ISD, because it seemed most similar to me, where you have a taxing entity that has an authorized tax, and we don't contest that in 1974 a tax was authorized for a particular purpose. Those jurisdictions expanded in those cases their territory. In this case, they've expanded their function. In the courts, and this court held in the Crowd case, that you have to go back to the taxpayers and get permission to tax for that expanded purpose or for that expanded territory. So to me, those seemed the most appropriate, but we'll accept and find either way.
If South Texas ISD were to say, all right, fine, we'll go back and just run the kind of school system that we had when Willacy County voters approved it, would you agree that they could still tax up to 5 cents on $100?
We would not be before you today if South Texas ISD were providing the services to disabled youth in the Rio Grande Valley that they were established to provide job training and those extra services that could not be provided by the school districts. We would not be here today.
So the question then that's tricky about this is it that you're really challenging the tax itself, or are you challenging how the government is using the tax? And that's where the particularized grievance does come in. If it's just the use of it, everybody's similarly situated there. That's all the federal cases that are debated, trying to use the courts to control the government by a taxpayer saying, well, I paid $100 in tax, so I want to have the purchase of this nuclear submarine declared illegal or something like that. Versus, this tax was never actually authorized. The legislature didn't approve this. The voters didn't actually approve this. That's where I'm trying to figure out what your argument really is.
It's both of those. It's the first argument, Article 7, Section 3 says in order to collect a school tax in the state of Texas, the voters must approve an election for that purpose of operating a school. That has never happened. On the flip side of that, Article 1, Section 6.
Well, no, the voters approved the tax for the purpose of operating a school, but your argument is that it was a particular kind of school, and that is where it departs from the authorization.
It was not a school. And this 5-cent tax is not a school tax. It was a rehabilitation district tax.
I thought you said it would be fine if the school district was engaged in vocational education.
They're providing vocational training.
Right.
And for handicapped youth.
So it's a question of, and it's under the auspices of the school taxing authority. I don't think anybody argues that. But that was the auspices of it. But you're just saying they're not complying with what the voters approved.
I'm saying both. A school tax in Texas, we just had an election yesterday about a homestead exemption for school taxes. But the homestead exemption does not apply to self-taxed, for example. We have other exemptions from school taxes in Texas. Those exemptions are not applied to self-taxed ISDs. It's a special purpose district tax. And if they were providing rehabilitation services, that would not constitute a free and appropriate public education for state and federal law purposes. It's not a school. It could be a training program. It could, I think the expanded scope of their authority allows them to provide special services to at-risk youth who are at risk of dropping out of school that are otherwise fitting into the school system. But they never have had a either statutory authority to operate a comprehensive school, which we're not challenging their ability to operate. We're simply challenging their ability to tax an enrichment tax that no other school district in the state can tax.
Now, they do all the things that you say that they should have done if they were approved to do, but then your complaint, I think, is they also do a lot more that maybe was not envisioned in 1974.
In 1974, students with disabilities were not served in public education, sometimes at all. They were sometimes excluded. And so there was a real need for those students to have some access to education.
Well, my point, though, is that today, in 2025, South Texas ISD is providing, the argument is a very small amount, but they're providing services to people, even coming from other school districts, as I understand it, to some extent, that satisfies those original rehabilitative, vocational purposes, et cetera, et cetera. Your complaint is not that they're not doing it at all. You're saying, yes, but you've now built on this tiny foundation and you're doing a whole bunch of it. Am I understanding your argument?
Yes. Yes, they've expanded the scope so that it is no longer a rehabilitation district. It is an all-purpose general school. And their special education population is less than 4% of their enrollment, which typically in the public school in Texas is more like 10%.
And how are the members of the board chosen?
I haven't focused on that. It's a combination of appointment by the county judges, I believe, in elections.
I mean, there's another path for the governance of the school. It's not like something was created and now it just goes off and frolic, and unless the Supreme Court of Texas steps in and takes control, there's no way for the people of the three counties to exert their self-governance. They still are in control of this board, correct?
The board is filled by appointment from elected officials and by election. But I think we're in the briefing, they mentioned South Texas argues, well, why don't you just vote to leave? But you cannot leave the district. There's no statutory way to leave the district. In our voters, they may vote to assess the tax and participate in the district. But that has never happened, and the Constitution at a minimum requires that to take place.
Do we have to decide any of that at this stage? I mean, we're just talking about standing, so do we have to decide who's right in order to answer the standing question?
No. The only question before the court today is standing. But I do want to talk, so a little bit about what's different about South Texas ISD and to the question of whether it's a school district. South Texas is the only school district in the state that collects a Tier 3 enrichment tax. So Tier 1 is paid for by the state, Tier 2 is paid for by the state. It's funded like a charter school or school district located in a military base where they don't have a local property tax base. And so the state guarantees that they get full funding, the same as every other school district, and they're not penalized for not having a local property tax base. And that's where the Court of Appeals, I think, erred.
Any further questions? Counsel, we'll hear from the respondent.
May it please the court, Mr. Gagey will present argument for the respondent.
Mr. Chief Justice, and may it please the court. Harth Gagey on behalf of respondent South Texas ISD. I want to roadmap 4 points quickly that I hope to make in my time today. First, this court should hold that the individual petitioners lack standing because they cannot allege either an illegal expenditure or an illegal collection of taxpayer funds. In fact, individual petitioners are trying to mix and match an illegal expenditure and an illegal collection theory. The general rule is that taxpayers do not have standing to air generalized grievances about the conduct of government or allocation of power. There is a limited exception for cases where the plaintiffs seek to enjoin either an illegal expenditure or an illegal collection. But individual petitioners have to show that they're taxpayers and public funds are being expended on allegedly illegal activity or being collected without authorization. Such suits are drastic, and that's why this court has required plaintiffs to bring themselves strictly within the established rules.
Why wouldn't we distinguish between collection and expenditure under the theory that the expenditure has a diffuse effect, and if you can't show that it has a particular effect on you, then perhaps there's a strong argument that you lack standing. Whereas the collection, as to each taxpayer, is, it would seem to me, a classic particularized injury. They're making you fork over money. I mean, what could be more injurious than that?
Because, Mr. Chief Justice, I think you just heard my friend on the other side confess that what they're trying to do is get an injunction against collection, but on a theory based on expenditures. That's what it's.
So I understand that point, that there's a little bit of a confluence here of the theories, but just in the abstract, just the district is collecting a tax that's just flatly prohibited by some provision of the Texas Constitution. It's an income tax, or no standing, you charge me $1,000 in income tax. The law says you can't do it. I have no standing because you're charging everybody $1,000 in income tax.
Your Honor, I read Perez versus Turner to say exactly that even if it's a collection case, you have to fall within the paradigm of the taxpayer standing laws. In that case, Your Honor noted that this court had held that City Charter had been improperly passed. The court had already held that, and so there's a basis to say, well, this tax that was being assessed was unauthorized, and therefore you have taxpayer standing under illegal collection theory. But that's what they don't have here. They keep repeating the refrain that there was an illegal tax because there's never been a vote. But it's uncontested that in 1974 there was a vote, and I invite the court to look at tab 4, which is the special election order from 1974. And you'll notice that there is no contention in this case that this vote did not occur, or that Willacy County did not join South Texas ISD. And so that's why they default back to saying, well, what the vote was really for is it said the purpose of the tax was to educate handicapped students only. So that's why they're blending that collection theory into their expenditure
So
theory.
your theory of how standing ought to work, then is the substantial disruption going to be an issue in every single taxpayer challenge? So, and is that right? And so what would the burden be then that the taxpayer has to come in and say this wouldn't be a substantial disruption to the government operations? Or
Your Honor, in Jones, this court said that the burden to prove standing is always on the plaintiff. And And so our position would be that it is the plaintiffs that have to show that following the taxpayer standing doctrine and that there is no severe disruption on the governmental unit against which they're seeking an injunction.
That's tell me why the idea of there being a severe disruption has anything to do with standing. I get it that Lou, like a half a sentence said that, but what in the world do those two things have to do with each other?
Your Honor, it goes back to the very foundational principles, starting with Osborne versus Keith from 1944 from this court, where this court said that governments cannot operate if every citizen who concludes that a public official has abused his discretion is granted the right to come into court and bring such officials' public acts under judicial review. And that's why both in Jones and Perez, when this court was doing a taxpayer standing analysis, it reaffirmed that reading of Bland because it said the rationale for affording taxpayer standing is protecting the public from illegal expenditures, but without hampering severely the workings of government.
It just seems to me like you're in the worst case with that. You're kind of in between two principles. I mean, on the one hand, what you read from Osborne sounds like pretty much the federal doctrine in which taxpayer standing is not going to be permitted unless you have the Article 3 requirements, right? Or we could say, well, if a taxpayer has standing because the government's doing something unlawful, they've got standing, and maybe there are merits arguments. Maybe something like the idea that this has been going on for 40 years is a laches type of thing, or maybe the burden is really high, but how is it a jurisdictional consideration? That's what I'm trying to get at. I'm wondering if the thing in blue is just a half a thought that was really getting at the idea, well, we're not going to entertain this kind of thing. I think it was in the context of we're not going to expand what seems like it's already a questionable exception.
Your Honor, my response to that would be there is a certain tension between the federal cases and the Texas taxpayer standing cases. But blue, I don't think, is a half thought. Blue is a conscientious decision because this court recognized that when there's already substantial investment by the school district, when there's settled expectations of other taxpayers who are also in the district, and when there's increased risk to lenders and others who are dealing with the district, there has to be some limiting principles.
So why is it jurisdictional? The injury to me, and whether a court will hear it, it doesn't seem to make a lot of sense to me to say, well, the same thing happened to me, and as long as other people didn't rely too much on it, the court can hear my case, but if they did, the court can't even hear my case. I can see why it might rule against me if other people's interests are at stake. But to say, well, no, we're going to pretend as though this is not even a case where it would be a case otherwise, it seems like we're mixing and matching.
Well, Your Honor, I would respond to that in two ways. I mean, the most basic response is Bland tells us it is a jurisdictional inquiry, and so that's why we think it is. Obviously, if the court wanted to rewrite Bland and put disruption in another category, the court could do so. But I think
Henry tells us that the threshold inquiry into standing in no way depends on the merits of the plaintiff's contention that the particular conduct is illegal.
Yes, sir.
So, and there's, the reason we have taxpayer standing in Texas where we don't have it under the federal regime is that our Constitution is very long, and it just got longer, and there are all these very particularized restrictions on how you can spend money in our Constitution and how you can collect money and what you can spend it on that aren't in the federal Constitution. So our cases allow those to be enforced under certain circumstances.
Your Honor, I would agree with the basic premise of the question that there's a distinction between the merits question and the pleadings question. But the issue here, I think, and this might be a silly example, but I think it perfectly encapsulates why I think there has to be some analysis about the bases that they have alleged, is could a plaintiff show and say, well, the South Texas ISD ad valorem tax is illegal, and then just cite the green cheese principle. Obviously, that couldn't possibly satisfy the allegation burden, even at the plea of the jurisdiction stage.
They've done a good deal more than that here.
Well, but I'd like to fight with my friend on the other side on that issue.
Wouldn't that be a 91A merits dismissal as opposed to standing?
No, Your Honor, I don't think so, because every time you have afforded someone taxpayer standing, what you have looked for is some kind of prohibition or some kind of exclusive use provision. And so I go back to the Jones versus Turner case. In that case, the city charter clearly said the drainage fund must be exclusively used for drainage purposes. They can't list that here. Or in the Williams versus Lara case, the establishment clause prohibited the very kind of expenditure that was at issue. And really, you could say, clearly, they've met the allegation threshold.
Well, their argument is that the language you highlighted in green on tab 4 is a limit on what you could use the tax revenue for, and you're not complying with that.
But, Your Honor, what I would...
That seems just like the drainage issue.
Well, Your Honor, I would have 4 reasons why I disagree with that reading of the special election order.
Well, why is that a merits question?
Because, Your Honor, they have to find some kind of prohibition or exclusive use type language to say, I have an allegation to show taxpayer standing to get into court. None of these sentences highlighted in green give you an exclusive prohibition or exclusive use provision. For example, the very first green highlighted sentence, it talks about the board's discretion to educate as it deems appropriate the handicapped students. The second and third sentences are about maintenance and operation standing alone. And the third sentence is about levying the tax without any purpose. I keep hearing my friend on the other side say the words for the purpose. The tax was assessed for the purpose of. But when I read this last sentence in green, I don't see the words for the purpose of. And then I push a little bit even further and call your attention to the sentence highlighted in yellow at the very bottom of that page. All as authorized and provided for in House Bill 167, passed at the regular session of the 58th legislature. So let's talk about what that House Bill 167 said in 1963 before any of these votes were taken. I direct your attention to tab 2. In tab 2, I've shown you, I think, 2 really important provisions that show that they cannot possibly meet the burden of alleging some kind of prohibition or some kind of exclusive use provision. Section 26.72 gives South Texas ISD all powers relating to the acquisition of land and to the construction or acquisition of facilities and to taxation vested by law in independent school districts. And that language is not something that was added later to the statute. That was actually in the enabling statute starting from 1963. Similarly, Section 26.69 says the board may levy taxes and distribute the taxes as it may deem necessary for providing needed housing and facilities and for the support of the rehabilitation program. And again,
what they're saying you're not doing is the rehabilitation program.
But Your Honor, what I would say to that is there is no provision in here that's saying exclusive use or a prohibition. In fact, what I just read to you...
Language of the actual ballot that is what the voters actually saw in 1974.
Your Honor,
play into this because it says the purpose of the rehabilitation district is to acquire and construct residence centers and other facilities as the board may deem necessary or proper for the training and guidance of handicapped trainees.
Your Honor, what I would say to those very words is that it's more expansive than even the 13th court gave it credit for, because it's talking about what the board may deem proper. It's giving the board some level of discretion. And so the board...
And also, that's a limiter. And wouldn't you agree with me that's a limiter for the purpose, for the training and guidance of handicapped trainees?
I would agree with that, Your Honor. But this is not a situation where South Texas ISD has stopped educating special education students and completely started educating the non-special education students. And so, if in its discretion the board decides, you know what, the federal guidelines of least restrictive environment for special education students is the way we want to conduct business, and that's why we need non-special education students, that special education students can have a least restrictive environment. This language is giving them that discretion. I'd also point,
if we're using the tax to build submarines, would you say there's taxpayer standing?
Your Honor, I would agree. But that hypothetical is so far outside the bounds of what's happening here, I don't think it really informs our analysis. Here, there are special education students that still attend South Texas ISD. They're still being educated by the district, and the district is just doing it in a way that the federal guidelines ask us to do. And I'd like to make 2 additional points.
Before you get to that, though, it seems like if you agree they were using the tax to build submarines, they would have taxpayer standing, and there's really not this distinction between collection and expenditure. Because you're saying, well, it kind of falls between, and so it's either one, but you just said if they were spending it on submarines, then you could sue.
Well, to enjoin the expenditure on the submarines. That would be an illegal expenditure theory. The illegal collection theory, which they refer to, is from Article 7, Section 3E, but this court, starting from the LaSalle Bank case in 2007, has said that the Constitution must be read for its literal meaning, and in this case, Article 7, Section 3E only requires that the voters shall approve the tax. It does not say the voters shall approve the tax and the purpose for which the tax will be used.
If it's illegal to expend the tax, why isn't it illegal to collect it?
Well, Your Honor, the way I understand this court's jurisprudence, Jones is the seminal illegal expenditure case where you say, the tax was appropriately approved, but you're using it in manners that were not allowed. And so the city has to put back the funds into the drainage fund. Versus,
So they just asked for the wrong relief and could replead to enjoin the expenditures.
but Your Honor, let's talk about that because that relates to a question that I believe Justice Young asked my friend on the other side, which is, if South Texas ISD were just educating special education students, would you be here? The answer I heard is, we wouldn't be here. But consider the counterfactual they want us to engage in. They want us to violate federal law and the requirements of the least restrictive environment for special education students. And then they would say, well, okay, in that case, there is no illegal expenditure. So, they're trying to prove illegality, but their counterfactual would actually ask us to violate federal law. That cannot be a case.
But everything that South Texas ISD is required by federal law.
Your Honor, can you repeat the question?
All the money that South Texas ISD expends and all of these programs you say is required by federal law.
No, Your Honor, that's not my contention. But my contention is...
How would enjoining those expenditures, if it turned out to be beyond what the voters had authorized, let's just hypothetically say, violate federal law?
Well, Your Honor, because if we couldn't expend funds on the education of non-special education students, essentially we wouldn't have any money to, have them in our school district. We wouldn't be providing the special education students with the least restrictive environment, which is required by federal law, and which, by the way, practical experience has taught our board is the most proper way of educating special education students. I'd also like to...
That sort of assumes a very drastic remedy. I mean, we're a long way from this, but down the road, the remedy here could be something like, y'all need to have an election. This is change in such a fundamental way that go have an election and let the people of the county decide whether they want to fund a school district like this.
Your Honor, I'm glad you asked that question because I do not see a way how South Texas ISD could, of its own free will, go to the voters and propose a proposition that's not in the enabling statute. And what I would refer you to is sections 26.13 through 26.18. The legislative scheme only contemplates a vote when there is a creation of the district and annexation. It doesn't give us the authority to conduct other votes that are not in the legislation. And so, necessarily, to side with the other side, you would have to conclude that the legislature has somehow made a mistake and, I guess, unintentionally violated the Constitution. And here, the legislature has made a very intentional choice about a unique way to fund South Texas ISD. The ad valorem tax is an essential part of that funding. And so, this court has continuously said that it must take the legislature at its word, respect its policy choices, and resist revising statutes. I'd like to very quickly...
Just real quick on that, I take it from what you just said that if the Commissioner's Court of Willacy County, what you have in tab 4 of your book, were to hold for a special election and just say this election is to decide whether the vote held on November 11th, 1974 shall be repudiated or reaffirmed, you would say that would be an illegal election, or what would your answer to that be?
Your Honor, I don't know what the answer to that would be in all candor because it's not in the enabling legislation. We do know that there are two political pathways that the other side has open to it. There are the board of directors. I checked this morning. There are 23 currently sitting board of directors. I believe 12 were appointed by the county judges of each of the districts, and then the others were elected. They could use that political process, or they could go to the legislature, ask for an amendment, either to allow a vote to leave South Texas ISD, or to take away the ad valorem tax power, or to limit it somehow. But they tried to do that, and they weren't successful. And so the solution here really lies in the political process. I have 1 minute
just mentioned. What's your best argument for why an ultra virus action wouldn't work?
Your Honor, I go back to the same issues that are brought up today, which is there illegal expenditure? And my answer is there is not an illegal expenditure because they cannot point to prohibition or exclusive use provision. And what we see is actually since 1963, the board had expansive additional powers. And that's why even if they brought an ultra virus claim, it would not be a viable one, as the court found in Perez versus Turner. I have 20 seconds left, and I want to touch very briefly on the disruption point since I've not had any questions on that issue. The characterization that the other side has made about our overfunding or double funding, we have rebutted both in our briefing and in our response to the motion for temporary injunction. I would just add that the way the other side characterizes how we do the Tier 1, Tier 2 calculation is not entirely accurate, and that's why I've included tab 6 and 7 in this bench book. I invite the court to look at it. I'm happy to answer any other questions that the court may have. Otherwise,
any other questions? Thank you, Mr. Gidgey. Ms. Leon, you have 5 minutes.
I think it's significant that in the briefing, it was repeatedly argued that all Willacy County needs to do is to vote to exit. But as we hear today, no one in the rehabilitation district or the rehabilitation district itself has the ability to initiate that kind of election.
Could the Commissioners Court of Willacy County call for another ratifying election, let's say?
I'm not a county lawyer, but I don't see any statutory authority for such an election. The statute in question, former Chapter 26, did not contemplate what would happen next. And so, as this is the only district that exists, we don't know. I think the court should be troubled on the question of disruption. Why the Texas Public School District is standing before this court and arguing that it is disrupted by having to operate a public school with the same funding as every other school district in the state. Now, at this point in time, only Willacy County is seeking to leave the district. Willacy County pays, according to the 2025 certified property values on the 3 websites of the CED, the county appraisal districts. Willacy County comprises 2.8% of the tax revenue for South Texas ISD. So all of this discussion of defunding and shutting doors and so forth is completely effective. And even if all 3 of the counties were ultimately to join the suit and opt out of being taxed without having first had the opportunity to vote, South Texas ISD would be left with the same funding as every other public charter school and any other property poor school district because they wouldn't have a tax base or a school district operating on a military.
It wouldn't be that with other counties, it would just be any taxpayer in those counties. And so what is the counties? You mean a handful of people in Willacy County. And if we got a handful of people in Hidalgo County, a handful in Campbell County, her theory of the law is the school district is destroyed.
Their theory of the law is that their school district is destroyed.
You're saying that these people can all have standing in common because the school district doesn't have a means of having an election to ratify this kind of stuff. As it stands, the courts would say it's operating legally, no more taxes, none of this.
The Commissioner of Education has taken the formal position that South Texas ISD may operate as a school. That's within the Commissioner's authority. And the legislature has authorized funding for South Texas ISD, the same as every other public school district.
But isn't your suit second guessing those decisions?
Those decisions.
In other words, you don't agree with the Commissioner of Education.
The Commissioner of Education has issued a letter ruling to the AG.
Right, but this suit challenges that conclusion.
We are not challenging their ability to operate as a school. That challenge has not been made.
So I'm confused. It sounds like from what I heard you say was that if you're successful and these taxpayers don't have to pay tax directly to the district, that's not going to prevent them from getting tax money from the state under the commissioner's decision, the same as every other school district. So the result of your suit would not be to shut the district down. It would just be they rely on the state funding that every other school district gets.
It would level the playing field financially between the school districts that are taxed by South Texas ISD and South Texas ISD. They would all receive the same amount of funding. South Texas ISD is the only school district in the state that it is immune from recapture.
So you're just saying the extra taxes that you're having to pay would go away, and they'd be reliant on the state funding system just like everybody else.
That's correct, and as a matter of law, that cannot be disruptive. That cannot be restopped. Their argument throughout this.
Sorry, two questions. Why do you need the taxpayer standing doctrine to establish standing for these taxpayers? Since you're not trying to stop an expenditure, you're not arguing, keep taking our money, just don't spend it on this thing. You're saying stop taking our money, right? So why do you even need taxpayer standing doctrine? Do you? Injury in fact. The government took my money. Causation. It was the government that took it. Regressibility. Stop taking it. What's hard about that?
I guess it shouldn't be hard, and when we get remanded to the trial court, we'll amend our pleadings accordingly. But I think that the taxpayers do have the ability to contest an unlawful tax.
And the other question that I had, just going to the remedy, I think you represent 16 individual taxpayers. Is that right? Were you to succeed on the merits, would the injunction run only as to those 16 people not paying 5 cents per $100 ad valorem, or would it run for all of the taxpayers that South Texas ISD is taxing?
I also represent the school districts, the school district and 16 taxpayers, and it's our position that it's Willacy County as a whole. If it's unlawful as to the 16 taxpayers, it's unlawful to all.
Well, that's right, but the remedial power of the court do we have to agree with you that the ISD that you represent, if we don't agree with you that they're standing as to that, then what result as to the remedy? We want it to be countywide, but
we're asking for countywide. I recognize the authority of this court to fashion the appropriate order.
Any further questions? Thank you, Ms. Leon. Thank you to all counsel. The case is submitted and the court will take another brief recess.
All rise.